Assalamualaikum. My name is Aufa Nazihah binti Muhammad Ajiji. I from class DPM 5A. Today, I would like present about procedure of repossession under Hire Purchase Act 1967. This is content of my video. First, definition of repossession. Second, repossession based Hire Purchase Act 1967. Third, types of loan. 4. Repossession example. 5. Procedure of repossession. 6. Right and protection of hires. And last, conclusion. First, definition about repossession. Repossession is the term used to describe the taking back of property after a borrower has defaulted on payment. The lender either repossesses the collateral or pay a third-party service to do so. Repossession based on Hire Purchase Act 1967. The Malaysian Hire Purchase Act 1967 provides several remedies to the owner of goods let out on hire purchase in case of a breach of the hire purchase agreement by the hire. Repossession of the hire purchase goods is one of such remedies. Repossession occurs when the hire has defaulted in the payment of installment. In reality, repossession of the hire purchase good strikes at a core feature of a hire purchase transaction. It denies the hire the possession of the hire purchase goods. Therefore, the remedy of repossession is not likely administered. Repossession entails the good instead of being in the custody of the hire finding their way back to the owner. Upon repossession of the goods by the owner at-on has possession of and property in the goods. From the perspective of the hire, upon the owner repossessing the goods, the hire loses his possession and the use of the hire purchase goods. Since the paper focus on the remedy of repossession, which is available to the owner of goods under the Malaysian Hire Purchase Act, it is important to point out from the very beginning the recent amendments were made to Act in 2010. The amendment came into force on 15 June 2011. The Hire Purchase Act 1967 lays down various restrictions on the power of the owner as a means of protecting the hires. It could be argued that the Act was intended to overcome the problem posed by the strict application of common law. The relevant provisions of the said Act are Section 16 to 19. In support of this provision, reference must also be made to the hire purchase, recovery of repossession, and maintenance of record by owner. Regulation 1976. The restriction imposed on the owner can be neatly explained in two situations, before and after repossession take place. There are two types of the loan. First, unsecured, and second, secured. Unsecured personal loan allows you to borrow money without providing collateral. A secured loan requires some kind of security and assurance that you will pay. When you take out a loan on a car, the lender knows that if you fail to make your monthly payment, it can repossess the automobile and sell it to mitigate the loss. You must probably promise 3 things when you sign loan papers. First, you will pay the loan back. Second, if you fail to pay the loan back, the lender had the right to take the vehicle and sell it. And third, if the automobile was not worth enough to pay off the entirety of your debt, you would still owe what was left. This is repossession example. Auto repossession stay your credit report for 7 years. The clock begins running on the original date of delinquency. Will it can negatively impact your credit throughout those 7 years. The impact can lessen over time, particularly if you have managed to improve your credit history as you prove that you pay your bills on time. Okay, in the words, a repossession that looks like an anomaly will impact you less than a repossession that appear to be part of a pattern. Before you simply stop making payment on your car loan, check with your lender. If you have experienced a layoff or other hardship, let your lender know. It is possible it will help you by altering your original agreement or extending your loan. To be sure, what the lender really wants is the vehicle to be paid off in full, something that is unlikely to happen if your collateral is repossessed and sold. Okay, this is 5 procedure of repossession. First, banking institution give 4 schedule notice, 21 days to inform you that it intend to repossess the vehicle. Second, banking institution give second notice to inform you its intention of repossess the motor vehicle. Third, banking institution repossesses the motor vehicle upon expiry to 4th schedule notice. Fourth, banking institution give 5 schedule notice, hire to exercise right within 21 days. Okay, the last, banking institution sells motor vehicle upon expiry of 5 schedule notice. Procedure during repossession. After the goods has been repossessed from the hires, the owner must serve personally a document acknowledge receipt of the goods. This document contains a short description of the goods, the date, time and place where repossession of the goods had taken place. If the repossession is being carried out by the owner personally, he must produce and show his identity card and provide the name and address of the company, firm, body or organization to which he belongs to the hires, his servant or agent or occupant or person who is in possession of the goods, or if the repossession is being carried out by the agent or servant of the owner. He must produce and show his identity card and also his authority card to the hire, his servant or agent or person who is in possession of the goods. The new amendment to the Hire Purchase Act 1967 has inserted new section in relation to permit for repossession. The new section of Section 17A and 17B. 17A is no person shall undertake repossession of goods comprised in a hire purchase agreement without a written permit issued by the controller. Second, any person who contravenes subsection 1 shall be guilty of an offence under this Act. 17B. First, an owner shall appoint as his agent to undertake the repossession of goods comprised in a hire purchase agreement a person who is a permit holder under subsection 17A. By virtue of the above provision, under the present law, only a person that is given the written permit can execute the repossession process. The permit is issued by the controller, which means that it is directly controlled by the government. The controller is the owner. Therefore, when it engage an agent to execute the repossession, that particular agent must have a permit. This requirement is imposed in response to the complaint that the ministry always receives from the public on the conduct of certain repossession men when they repossess the vehicle from the hires. This amendment, therefore, is specifically meant to address the common problem that is encountered in automotive industry. Then, procedure after repossession. After the goods being repossessed from the hire, the owner is required to serve the 5th schedule notice on the hire and his guarantor. If any, this must be done by the owner within 21 days after repossession take place. This notice contains information on the right of the hire after repossession. Within 21 days after the service of 5th schedule notice, if the hire makes payment of the amount due to the owner or when the hire has remedied any breach of the agreement or has paid the owner the costs and expenses incurred by the owner in remedying the breach, the hire may give a written notice to the owner to request the owner to deliver the repossessed goods. That is why the law strictly restricts of the owner from selling or disposing the goods until the expiration of the 21 days notice in the 5th schedule unless with consent of the hire. The hire may introduce a cash buyer to buy the repossessed goods by giving a written notice to the owner. If the value of repossessed goods exceed the money owed to the owner, the hire has the right to recover the difference from the owner. When the owner decides to sell the repossessed goods through public auction, the owner is required to give a notice to the hire. In case where the owner decides not to sell the goods through public auction, the owner must give an option to the hire to purchase the repossessed goods, but at a price lower than the estimated value of the owner. Whether the repossessed goods is sold through public auction or no, if the proceed from the sale is not enough to recover the debt of the hire to the owner shall proceed against the hire to recover such sum through an ordinary civil suit. Right and protection of hire. In the course of purchasing the goods, a purchaser that will become a hire upon completion of the hire purchase agreement will deal with a dealer or seller. There will be a case where a dealer or seller commits the act of misrepresentation towards a purchaser. For instance, give wrong information as to the year the goods was manufactured with the intention to deceive a purchaser, because he, a dealer or seller, know that a purchaser may not interested to buy the car if he know that the car manufactured in certain particular year. In this circumstance, a hire is entitled to claim from the owner or any person making misrepresentation in the course of the purchasing or negotiation that leading to the hire purchase agreement. A hire may sue the dealer or seller or their agent as well as the owner for damage and rescind the hire purchase agreement. However, since the dealer or seller is regarded As the agent of the owner, the latter may claim an indemnification from the dealer or seller. The right protection of hire according to the HPA will be available once the hire purchase agreement has been concluded in accordance with the requirement imposed by the HPA. Those rights and protection are derived from the implied condition and warranty that are given to the goods hire. On the other hand, as far as the right and protection for the owner is concerned, it will be related to right to repossess the goods hire on the hire default in making scheduled payment. The implied condition, the warranties that are applied or the goods hire to the hire are similar to the implied condition and warranty that are offered to the goods that are sold according to the Sales of Goods Act 1957. As to implied condition in hire purchase agreement, there are three implied conditions where the owner has the right to sell the goods at the time when the property is to pass. The goods hire must be of merchantable quality. Of the goods hire must be fit for the highest purpose. There is no definition of merchantable quality available in the Hire Purchase Act 1967. Thus, the meaning of merchantable quality as provided in the Sale of Goods Act 1957 shall be referred to merchantable quality means the goods are fit for particular use to which the said goods were sold. Thus, if the goods is of no quality and defective, it can be considered as of the merchantable quality, whereby as to implied condition that the goods hire must be fit for hire purpose. It does not applicable to the hire if he purchased the second-hand goods, and where exclusion of the implied condition and warranty as to fitness is expressly spelled out in the agreement. It seems that when the good is of no merchantable quality, it may not be fit for hire purpose as well. Okay, on the other hand, there are two implied warranty available in the hire purchase agreement that include the right of hire to enjoy quiet repossession of the goods, and the goods hire should be free from any charge or encumbrance created by the owner in favour of any third party. Quiet possession means there shall be no interference by the seller as to enable the hire to enjoy the goods, or any interference arising from lawful act of the third party. Okay, this is insurance. The owner has to take the insurance cover in the name of the hire for the goods under the hire purchase agreement. If the hire goods is motor vehicle, the owner shall take the insurance cover for the first year of the agreement. For the following years, it is the duty of the hire to insure the goods. As for other type of goods, the insurance cover must be taken out throughout the duration of the goods remain under hire purchase. When the hire renew the insurance for motor vehicle, the hire must inform the owner that he has renewed the policy not less than 14 days before the expiry of the said insurance. If the hire does not renew the insurance policy, the owner may insure the motor vehicle and the cost is to be borne by the hire. The last is conclusion. It is evident from the above discussion that the owner has the right to repossession of the hire purchased goods if the hire commits a breach of his obligation under the hire purchase agreement, usually non-payment of installment. The governing statute on hire purchase in Malaysia has been around for some time. Though it chapter the important remedy of repossession, that the owner can exercise in a hire purchase transaction. There are gaps to fill in its provision regarding the enforcement of this all-important remedy available to indemnified owner. There is no doubt, however, that the provision of the Act seems to be overprotective of the hire. For example, the consequence of non-compliance with Section 16 by the owner tends to create an imbalance in the scale of justice in hire purchase agreement. This is by the virtue of Section 16, which is impose a penalty on the owner who failed to serve a Section 16 notice. The right of the owner under the hire purchase agreement would case and determine. It would seem that the owner would not be able to enforce any remedy given to him by the agreement to recover any amount from the hire. However, if the hire exercise his right under this Act to recover the goods repossessed by the owner, the agreement will have the same force and effect in relation to the right and liabilities of the owner and the hire as it would have had if the notice had been duly given. Thus, it is hereby recommended that Section 16 of the Act should be amended in order to remove the kind of imbalance in the scale of justice as far as hire purchase transactions are concerned. Thank you for watching my video. Assalamualaikum.